Hello everyone and welcome to Taylor Wessing's latest business immigration webinar. Over the next 45 minutes or so, we want to share with you some practical guidance on how European workers in the UK can safeguard their immigration status in light of Brexit. That's something that we're asked about every day, and also the latest rule changes and top tips for Tier 2 visas and managing Tier 2 sponsor licenses. My name is Charlie Pring and I'm pleased to be joined today by my colleague Vicky Weiberg.
Good afternoon.
We are both senior counsel in Taylor Wessing's mobility team, and we both specialise in helping UK and international employers with all of their business immigration requirements. Just a little housekeeping before we get started. If you do have any questions, please do type them into the box provided. We may read these out as we go along or cover them at the end when there should be some time for questions. To set the scene for this webinar, we can all see immigration continuing to drive debate and influence political policy making across the world. In the last few weeks, we've seen the beginnings of a US hire American policy, a new Kiwi first immigration policy in New Zealand, and new visa restrictions on the 457 worker visa scheme in Australia. Of course, the UK is not immune from this, with immigration being one of the key drivers behind Brexit and an important issue for voters in the upcoming UK general election on the 8th of June. In the last couple of days, media reports indicate that the Conservative Party will maintain its promise to reduce net migration to below 100,000 per year. Having failed to get near to that target for 6 consecutive years, this suggests to us that as well as ending free movement for European citizens, the new incoming UK government could introduce some radical new restrictions to move towards meeting that target in future years. That makes today's webinar even more pertinent as we will cover the proactive steps that UK businesses should take now to try and stay ahead of the game. So what are we going to cover today? Firstly, a quick introduction to us and to Brexit. One of the most important things for business to think about are what are the application options available to their European workforce in the UK to try and safeguard their status in light of Brexit. There are 2 applications available. Permanent residence is indefinite stay, and that's the most valuable one, but also registration certificates for workers that are not eligible yet for permanent stay. What proactive steps can businesses take to support their workers and to reassure them in light of Brexit that their status is going to be preserved? And then Vicky is also then going to go on and talk about the latest visa changes for Tier 2 sponsors that came in last month, covering both Tier 2 General and Tier 2 ICT, and a new immigration skills tax which applies to all Tier 2 sponsors in certain types of application. So a quick word about Taylor Wessing for those of you that haven't worked with us before. We're an international law firm operating across Europe, the Middle East and Asia. We're full service, but Vicky and I are both specialists in corporate immigration into the UK. So we're covering European applications, non-European applications, and everything relating to business immigration, so business travel, mergers and acquisitions, compliance and prevention of illegal working. So a quick introduction and to set the scene on Brexit. A lot of you will have heard a lot about Brexit already, but just a quick recap is that at the end of March, the UK government triggered Article 50 under the European Treaty, which starts the clock running on a 2-year negotiation period with the remaining 27 EU countries about the terms of the UK's exit. And that means that the UK will formally leave the EU in March 2019 unless the UK and the other 27 countries all agree to extend that period. The good news is that until March 19 at least, there is no change to the UK's legal rights until that point. So from an immigration point of view, that means that free movement of people and workers continues, the status quo continues until that date. There is absolutely no change in the rights of European citizens or their ability to live and work in the UK. That means your existing EU workers can continue to remain employed, and you can also take on new EU hires, whether they're already in the UK or even if they're arriving from overseas. There's no restriction on that ability until that point. It may be, and it's expected, that if a deal is reached between the EU and the UK, that there'll be some transitional period where free movement will continue for a period of time, perhaps 1 or 2 years, but that really depends on how the negotiations go. So one important thing to note is that there was a fear that there would be a cut-off date for rights that would be put into the Prime Minister's Article 50 letter, which was sent at the end of March. That hasn't happened, so there is no cut-off. So there shouldn't be a distinction in rights for EU citizens that arrived pre or post either the referendum date or the Article 50 date. There's no difference in approach to those individuals. The reason why this is important is that there's about thought to be 3.5 million EU citizens in the UK, 1 to 1.5 million British citizens working and living across the EU, and the EU and the UK are wanting to agree a reciprocal arrangement whereby the rights of both categories are reciprocal and are agreed. The EU, it's fair to say, wants to have a more generous settlement than the EU, respecting family member rights probably more than the UK will, and also the EU is pushing to try and reduce some of the red tape involved in permanent residence applications, and that's what we're going to come on and look at. So immigration continues to be headline news. We've selected a few extracts as we've gone along. I think one of the main things to pick out from these headlines is you'll see there that there's a rejection of applications by EU citizens for permanent residency at 28% at a point in time recently. And the reason for that is really twofold. One is about the supporting evidence required. There has historically been too much red tape and not enough clarity about the evidence that applicants needed to submit. But also there's a rather technical legal point for anyone who's relying on a period of time that they were a student or financially self-sufficient, that they had to have private medical insurance for the period of that particular type of stay. And it's not enough that the National Health Service was covering them. They had to actively have comprehensive sickness insurance. And that's catching out a lot of people because nobody knew that rule existed before the Brexit vote. And so it's a sort of a trap that has caught out quite a lot of applicants. So on the European side, what we're going to cover briefly is how European citizens can apply to confirm their permanent stay in the UK, but also how they can apply for registration certificates if they're not eligible for that yet. What we won't have time to cover are applications by family members and also applications for British citizenship by European citizens who have permanent residence. So under European law, the rights available to European citizens in the UK depend on that person being a qualified person. And that means that the individual must have been in one of 5 categories while they've been in the UK. So either as a worker or as an employee, which most of your workforce will be in the UK, or self-employed, a self-sufficient person, so that means financially independent, not needing to claim any public funds, a student, or a job seeker, an active job hunter. And you can add periods of time together in different categories when trying to achieve the 5 years needed for permanent residence. You don't have to have 5 years in one category. But as I mentioned before, if an applicant is relying on any period of self-sufficiency, so for example relying on a partner's income, or any period of study as a student, then they must have had comprehensive sickness insurance for that entire period. So one question we get asked a lot, especially in light of the fact that nothing is really changing until March 2019, is why should applicants take action now for permanent residence? Should they just wait and see what happens? Well, it's a perfectly fair question, and that is an option available. There is no legal requirement to do anything now, but there are some really good reasons why we would say applicants should take action and confirm their status if they're eligible. The first is to remove the ongoing concern about the outcome of the Brexit negotiations. I don't think there's any real fear that European citizens will have to leave the UK, but it's about whether their lives will become more difficult. Everything now is linked to immigration status, getting a bank account, renting an apartment, changing job, and if people's applications are stuck in the Home Office when another 3 million people are doing the same thing, then the delays will be worse and the opportunities for caseworking mistakes will increase. The process, although we mentioned the 28% refusal rate, the process has actually been simplified quite significantly recently. So there are new online forms. There's a passport return service so that applicants don't have to file their passport and they can still travel during the processing period. There's also been a reduction in the amount of supporting documents needed. So actually, although much of this hasn't been publicised by the government, the process for application is a lot simpler than it was, let's say, a month after the Brexit vote, because there's been a lot of complaint about just how complicated and convoluted the process had become. But now it is relatively straightforward, especially for your employees that have been employed for a full 5-year period and they're not relying, for example, on self-employment or study. One reason to get permanent residence is it's an indefinite right to stay, and you only lose that status if you leave the UK for at least 2 years. So it means that whatever happens in the Brexit negotiations, European citizens can know that they've got that indefinite right to remain. From a financial point of view, the current fee for permanent residence, the government fee, is relatively low. It's £65 per person. But if you compare that to the equivalent application by a non-European for indefinite leave to remain, that's almost £2,300. And that's because the UK is imposed by European law to charge a low fee. As soon as the UK leaves the EU, you can be sure that £65 fee will increase quite dramatically. The other final reason for permanent residence is that for anyone interested in getting British citizenship, it is now a mandatory stepping stone to getting a British passport. It used to be you could apply straight away after 5 or 6 years of residence, but now applicants must get permanent residence and to be able to get citizenship. So what does the application involve? One flag is that because of bilateral arrangements between the UK and Ireland, Irish citizens who are living in the UK are deemed to have permanent residence or settlement without having to make an application, although they can if they want to, because of course Irish citizens are also European citizens. But generally it means a 5-year continuous period in the UK. Importantly, it doesn't need to be the last 5 years. It can be any continuous 5-year period, and we'll come on to a good reason why you may not take the last 5 years. You must be as a qualified person, so one of the 5 categories we mentioned. If at any time in the period the applicant is a citizen of one of the Eastern European accession states, which required for a period in the early 2000s for them to be registered under the worker registration scheme, the applicant has to prove that they had that registration during that period. There is an absence test of no more than 6 months per year outside the UK. It used to be, again, in the more complicated system, you had to list every absence. Now, all you need to do through the online form is to tick a box to say that you haven't had that level of absence. So it's a lot easier. You do have to provide documentary evidence of your employment if you're in that category, and your residence. But again, it's really straightforward for an employee. All they need to show is 5 years of P60s to prove both residence and employment, or alternatively wage slips of at least 3 per year over the 5-year period. But it is a much easier process than it was even 6 months ago. So when you're choosing the PR date, you don't have to take the last 5 years. You can backdate that, and a couple of reasons why applicants are sometimes doing that. The first is that, as a general rule, you can only apply for British citizenship if you've held PR for at least 12 months. So if you can backdate it, so in other words, if you start your period at least 6 years ago, immediately on PR approval, you've held it for more than 12 months, and you can apply for citizenship straight away. The other reason is family related, is that if PR is backdated to before any European citizen children were born in the UK, they can immediately register as British. So there's a couple of reasons why it's a good thing to do. The earliest possible date you can backdate to is, I think, the 30th of April 2006, when the UK joined the relevant treaty, and flagged that if an applicant is taking a date more than 2 years ago, they also have to prove that they have been resident in the UK from the end of that 5 years right up until now, to prove that they haven't forfeited their status by leaving the UK for more than 2 years. So for people that haven't been in the UK for 5 years, they can still register under European law to show that they were exercising their treaty rights as a qualified person at a point in time, as long as they've been living in the UK for at least 3 months as a qualified person. And I think, generally speaking, we would say that if applicants are going to reach the 5 years before March 19, they'd probably wait and do the permanent residence application then. But if actually they're not reaching 5 years until beyond that date, there's a good reason to apply for a registration certificate. Again, it's only £65 to apply as a government fee. And if the UK government does try and impose some cut-off dates on rights, having a document that confirms that a European citizen was in the UK lawfully under EU law at a certain point in time may put them in a better position later on when all of these issues are examined. I mentioned before that the process has been simplified, and part of that is a new passport return service, which is being offered by local councils across the UK. What that means is that the applicant can file online, they can make an appointment at a local government office, and they leave their package with that government body. They copy the passport for the applicant, which means that the applicant can leave the appointment with their passport and is free to travel during the processing period, which might be 3 to 6 months. It used to be that applicants had to file their passport if they didn't have an ID card. This is a great way to ensure that applicants have the flexibility to continue to travel. You'll see there an overview of the timeline. It's an online form. You get the documents together. You go to your appointment. The government takes the fee, and then there's a decision within 6 months. And as I say, if you're able to keep your passport, that processing time isn't so important because they're free to travel. So I think probably the most important slide for businesses in this section of the webinar is how can companies proactively support their workforce, their European workforce in the UK. And we have seen, I think, a shift in approach with the companies that we speak to, probably since Christmas and early into this year, where there's a feeling that the UK government have not been able to guarantee the status of EU citizens, and therefore there's a sort of moral duty, if you like, on employers to reassure their staff and find ways in which they can proactively support their European workforce. And I think that shift in approach is starting to think about ways to secure status of European employees in the same way as you would for non-European employees. It's second nature for businesses to think about arranging visas for non-Europeans into the UK office, and that same sort of mindset is starting to be taken with European workers as well. There may be a legal argument to talk about discrimination, difference in approach between European and non-European, but I think more than that, it's about having a consistency of approach and ensuring that the European workforce are valued and that you're doing everything you can to reassure them about their future in the UK and in your business. So there are various things that you can do as a UK employer to support your European workers. That can range from providing them with information to arranging lawyers like Taylor Wessing to come in and give advisory presentations and then follow up with one-on-one individual surgeries or clinics with employees. We've done that on a number of occasions. You can instruct attorneys or lawyers to actually make applications for individuals on their behalf, or a sort of middle ground where the HR team of the UK business will collate documents, things like the P60s, the information needed for the forms, and then use that as a sort of central depository to work with the lawyers to file applications. So there are various different ways you can do it, but certainly where we've seen clients take that proactive approach, it has created some really goodwill with the workers who feel valued, and it's helped them to feel that they're valued in the UK. You should always consider whether your financial support will extend to family members of your employee in the same way as you would for non-European workers. The same principles will apply. So I'm now going to hand over to Vicky, who is going to speak about the latest changes that came in last month to Tier 2 visas for non-Europeans.
Thanks, Charlie. And I think whilst it's always important to be thinking about Brexit at the moment, we're very mindful that there are lots of changes that were introduced a month ago now, which will affect those Tier 2 sponsored workers that you might have in your workforce, and it's important that we don't lose sight of those, even whilst we're considering how to best support our European colleagues and staff members. So, as Charlie said, we're going to spend a little bit of time now just having a look at the Tier 2 changes. Charlie's already mentioned that UK immigration obviously remains a very hot topic, and we have even seen during the course of this week lots of news stories in relation to the tens of thousands pledge that the Conservatives maybe rashly issued 6 years ago when they pledged to reduce migration and have not been able to do that so far. So it's a topic which remains in the press, and I think will be one that will be thereabouts for the foreseeable future. So we had a number of changes that were introduced in November 2016, which you can see on the slide now. I don't want to focus on these long because I'm sure everybody is aware of those changes, but just to flag one or two things. There were a few changes in November which related to the ability of companies to recruit graduates. So the ability to switch graduates in roles without re-advertising a position if they have been on a graduate training programme, and also giving extra weighting within the annual restricted certificate cap, which is the cap applying to Tier 2 general visas in certain categories, where a business is sponsoring a UK graduate from overseas. And I think both of these things are very helpful, particularly with the removal of the Tier 1 post-study worker route some years ago now, which has made it more difficult for graduates to obtain roles within the UK. A number of the changes relate to salaries, which we flagged there, but those have been overtaken by changes in April 2017. One thing that I did want to just flag is that in November 2016, there was an abolition of the overstay period. And this was something that maybe slipped a little bit under the radar, but what it's meant is that people can only submit an out-of-time visa application now within 14 days of the visa expiry, rather than the previous 28 days. And there has to be a good reason for delay in submission, which is a new test. So it's really important, as we'll see slightly later on in the webinar, to be monitoring visa expiry dates and to make sure that you don't have a staff member who is prevented from extending their visa. So looking now to the changes which were introduced this April, I think that the main one to flag, which I'm sure everybody is aware of, is the introduction of the immigration skills charge for both Tier 2 General and ICT visa categories. And we'll talk about that a little bit later in my part of the presentation. So that's something that is going to make a difference to the number, maybe the number of people you're looking to sponsor in the UK and the cost for doing so. The second change was the increase in minimum salary for new applications under Tier 2 General. That was raised to £25,000 in November 2016 and has gone up again to £30,000. So there are some exemptions for new entrants. We've listed who would be considered to be a new entrant on the slide, and some temporary exemptions for some medical and teaching roles. But it does mean that maybe those people in roles which don't attract such a high starting salary may be prevented from applying under Tier 2 General now, so extra thought will need to be given. There is an increase to the high earner threshold to 159,600, and that's the threshold through which you do not need to advertise a position or be committed to having a minimum number of shareholdings within the company before making a visa application. So it's worth being aware of that. There have also been general salary increases under the stock code, so it's very important that you look to the latest stock code to ensure that the Tier 2 visa you're looking to issue meets the increase in salary. They haven't been particularly high across the different stock codes, but there is a change there. The other thing, which is a really helpful and very practical change, is the government has an expedited sponsor circumstances request, which you can use for a payment of £200. And that's really helpful because it allows certain applications which historically have taken up to 18 weeks to be processed in normally about 24 hours, although the Home Office would say up to 5 days. So things like adding level 1 users to your sponsorship licence or requesting additional certificates, which have taken a very long time to be processed up till now. And that's something that we've found. There's been an increase in the number of slots that are available every day recently, so we're finding we have good availability to use that scheme, and it's been very, very helpful. So again, there were some changes to Tier 2 ICT. We'll talk about the skills charge later. Two things that I think are very important here is the increase in minimum annual salary for Tier 2 ICT applications has risen to 41,500 for everybody apart from graduate trainees. Historically, there was the short-term route which closed from the 5th of April. And that means that you don't have an option to bring somebody into the UK for a shorter period of time on a slightly lower salary, and so that's going to be important to be aware of. The other thing which is quite important is that if you have a staff member that's paid at least $73,900, from the 6th of April, that person does not need to have 12 months prior service before they apply for an intercompany transfer visa. And I think that's going to be really useful because in that situation, before the 6th of April, we've had to look to Tier 2 General and the advertising requirements that fit under Tier 2 General. So the removal of that prior service, I think, will be really helpful to many of you. There's also a reduction in the ICT high earner salary to 120,000, and that's really helpful because under that category, ICT visa holders can stay for up to 9 years if they're paid 120,000 rather than 5 years. which can be very helpful, particularly given that the ICT route does not lead to settlement. So that's a really valuable change, I think. A slightly less positive change is the expansion of the NHS surcharge. So that's a charge levied now to all Tier 2 visa holders, not just Tier 2 general. And it's a £200 charge per visa year per applicant, so that includes family members as well. And that allows Tier 2 visa holders to have access to the NHS in the same way as British or European residents. So it is going to increase the cost of applying for a Tier 2 visa, but it's something that we were expecting to be rolled out before the 6th of April, so it's been good that it has been slightly delayed. So the big change from a cost perspective is the immigration skills levy. This is a government charge which is paid by all Tier 2 sponsors when you assign the certificate of sponsorship, and it's an annual charge of either £1,000 for a large sponsor or £364 for a small sponsor. Whether you're a large or a small sponsor will generally be decided by your sponsorship licence, but it's based on a Companies Act definition, and particularly centres around the number of employees you have. So if you have 50 or more employees in the UK, you're probably going to be a large sponsor as a starting point. But it is really important, because this is going to be so critical to the skills charge you pay, to go back and have a look at your sponsorship licence and make sure that you're that you have the right sponsorship type on your sponsorship licence, and make a change if necessary. So the charge, as I said, is an annual charge. It only applies to certificates assigned on or after the 6th of April in certain circumstances. So if the applicant is outside the UK, is inside the UK but switching to Tier 2 from a different category, or is extending their Tier 2 visa or changing employment from one Tier 2 general sponsor to another Tier 2 general sponsor, but again only where that person entered the UK, or entered Tier 2, after the 6th of April. So it's important to remember that if you have somebody who's already in the UK on a Tier 2 visa, and that was issued before the 6th of April, they're not going to be caught by the skills charge. There are some exemptions. The graduate trainee route is exempt. Tier 2 workers performing certain PhD level roles are exempt, so I think we'll be looking for that PhD route more under the stock code. A graduate who is on a Tier 4 student visa, if they switch to Tier 2 general, has a lot of flexibility, and they're going to be exempt. And also, this is just important to remember, this is a charge on the Tier 2 applicant and not on family members. So you don't need to pay a skills levy for each family member also coming into the UK. So there are some sort of practical points that we wanted to flag in relation to the skills levy. I think the first thing is that you need to think quite carefully about who can issue the certificate. The skills levy has to be paid when the certificate is issued, which means that you need to have somebody who has access to a credit card that has a credit limit that would allow you to pay the skills levy. You need to have somebody in the workforce who has you're going to be comfortable accessing the certificate, which will have personal data and information about the Tier 2 migrant you're sponsoring. So it's going to be important that you're comfortable with people who have access to that system. We've had some clients ask questions about whether or not it's possible to pass the skills charge on to the Tier 2 worker directly, and the guidance specifically prohibits that from taking place. It's intended to be a charge on employers looking to use Tier 2, and the money is being used by the Department of Education to address skills gaps training, and the Home Office has been very clear that this isn't a charge that employees should be asked to pay in order to obtain a UK visa. So our advice would strongly be that this is not something that you should be passing on to staff members were you to be thinking about doing that. There's also a kind of practical point around the refund process. So if you have a Tier 2 migrant and you apply for a 5-year visa, for example, at the outset, if that migrant worker moves on from your employment after, say, 2 years, then you will receive a refund of the remaining skills levy from the remaining 3 years. Now, it's too early really to understand how this is going to work in practice, but the Home Office guidance suggests that the money will just simply be refunded onto the credit card that pays the skills levy at the outset, and that you're not likely to receive any sort of warning email or reference or correspondence about that refund. And I think that's quite important, because if as an organisation you are sponsoring lots of workers in any one year, it's going to be difficult to see at the moment how you will be able to track refunds of that skills levy. So that's something that's going to remain to be seen in practice. But I think it's important, for example, that your level 1 user doesn't pay the skills levy on a personal credit card, for example, because the refunds would then come back to their personal credit card, and that person might in the meantime have left your employment. So there's going to be some sort of practical things to think about around how to arrange the skills levy. And as I said a few moments ago, it's going to be really important to be just reviewing your sponsor size on your license. Companies do grow over time, and it might be that you were a small sponsor and you're now a large sponsor, or in fact vice versa. So it's important to make sure that your size is reflecting correctly in the skills charge you may have. The next slide that you'll see on the screen now is just an overview of the impact of the skills charge and the NHS surcharge on the cost of visas. And you'll see particularly if you're making an application for Tier 2 visa holder who have family members, that's really where the extra costs are going to come in. So just some action points arising from the rule change. We've talked about whether or not you can claw back these costs from employees, and I think it's going to be very difficult to do that. There are the higher minimum salaries, and you might need to think about your impacts on workforce pay scales. If you pay people at a certain level the same salary, might you need to use cost of living allowances or other adjustments on international assignments? It's worth flagging that one thing that the 6th of April rule changes has done has also been to look at the allowances that you can include within qualifying salary for Tier 2 visas. So it's important that if you are offering an allowance or some other way of adjusting international assignments, that it is compliant with those slightly restricted rules. You also need to, I think at the moment, consider training and upskilling your resident workforce. I think that's particularly important with what Charlie has said in relation to potential visa issues for European nationals in the future. So it's probably something to consider now is, do you want to be spending money on the skills levy, or would you like to spend those funds on upskilling your resident workforce and looking to address some of the gaps there? So now that the visa, hopefully your Tier 2 visa has been granted, what do you need to do? And as Charlie said in the introduction, it's really important that you are aware of sponsorship compliance. The Home Office can audit at any time. It may or may not be an announced audit. We're seeing increasing numbers of unannounced audits, particularly if the Home Office visitors happen to be in the area at the time. And if they audit you, they are going to expect to see that at the point of audit you are compliant with your reporting rules, with your record-keeping rules, that you understand the sponsorship systems, that you have compliant files, for example. They might want to meet with your authorising officer, and they might want to speak to Tier 2 staff members and check that those staff members are being paid in compliance with their visa, for example. If the Home Office decides that you're not compliant with your sponsorship licence, they can choose to downgrade the licence, or they can suspend the licence for 3 months while they ask you to consider an action plan, or they can simply revoke the licence. And if they do that, that revocation will cancel any Tier 2 visas that you have sponsored. There is no right of appeal against the revocation of licence, and there's also a 12-month cooling off period under which you're not able to, the employees who are sponsored will need to leave the UK, and they won't be able to apply to come back into the UK for 12 months. So some quite serious implications if your licence is revoked. It's really important that from time to time you do audit your record keeping. You're very familiar with the Appendix D requirements and your reporting duties, and that you keep an eye on your sponsorship licence and make sure that you have the right files in place just in case you are audited. Over the next 2 slides, we've just set out a couple of the types of things that you might need to report to the UK Visa and Immigration Body. So we're not going to go through this, but if you have a change of name, that needs reporting. If you move address, your entity size changes, all of these things need reporting within 10 working days of the change. So it's quite a tight time frame for making a report. They're made online. Sometimes you need to submit supporting documentation. We can obviously help you with these if we're your level 1 user. There are also changes that have impact on an employee. So if their job title has changed, or they've changed work location, or they leave your employment, you will also need to report those, and again within 10 working days. There's no requirement to report annual pay increases, but it can be good practice, particularly if a pay increase can be, substantial. So it can be good just to look at your sponsorship license every year at the time that you do consider pay increases, and just check that your reporting is up to date at that time. So why is this all important? Well, there's very strict right to work rules which stem from the legislation on the slide in front of you. And the reason these are important is that if employees are employing anybody in the UK without the right to work, there can be a £20,000 civil penalty for each of those illegal workers. Coupled with that, from last year, the Immigration Act 2016 introduced a criminal liability knows or has reasonable cause to believe that somebody is working without permission in the UK. And the reasonable cause to believe is a much lower threshold than actual knowledge. So it's much easier for the Home Office to show that you may have someone on site and you should have known that they didn't have permission to work. And the maximum penalty under that criminal liability is 5 years in prison. We're not aware of anybody who has been subjected to 5 years in prison, but it is a pretty serious offence now. There's also a personal liability on an employee that they could be required to pay a fine of up to 51 weeks pay, or 6 months in prison themselves if they're found to be working illegally in the UK. So quite a serious charge against them. There's also an introduction of a penalty from December of last year that the Home Office has the power to close premises if their officials are reasonably satisfied that there's an illegal working offence being committed. There has to be a history of illegal working, so a civil penalty within the previous 3 years, and there's a very strict process that the Home Office officers have to go through in order to be given the power to close the premises. We're not aware of any premises being closed under this power yet, but it has only been in place for a few months. And I think Charlie and I see that this is something that might apply to maybe regular repeat offenders, probably smaller businesses who are known to be regularly employing people without permission. You can give yourself a statutory excuse if you have checked compliance documentation. And this has to be done for all staff, not just overseas nationals, not just non-EU nationals. And it has to be, the checks have to be carried out before the person starts work. And you have to keep certain documentation on your file. So you have to check the documents in front of the person that you're looking to employ. Generally, this is going to be the passport of that person. And if the person is a visa holder, you will probably also need to check the visa, whether in the passport or on a biometric residence permit card. And you need to check that that's a genuine document. So it's not just enough to quickly look at the document, but you need to look at it in detail. Make sure that it hasn't been tampered with. Make sure that it's still in date. It hasn't expired. The name matches the name of the person you think you're recruiting. You need to then make a copy of that to keep on your file and write on the copy that it's a genuine copy and date the copy and sign it. The person who has taken the copy needs to sign it so that if the Home Office has concerns about that record, they know who to talk to about it. There's also a very helpful right-to-work checklist that the Home Office has produced, and that's a document that you can keep on file, and you can show that you've been through the necessary checks and that you're comfortable that you have the correct documentation for that person. And the checklist has an opportunity to make a note of the date that the person's visa would expire, and we'd recommend that you also keep a tracking system whereby if you have overseas nationals working for you, that you keep a record of their visa expiry dates in your system, as well as a reminder maybe 3 or 4 months before the visa expiry to talk to your staff members next visa steps. And that allows you to approach the employee in good time, and particularly important given the November 2016 changes I mentioned, whereby there's much more restricted ability for staff members to extend their visa if they're applying after the visa has expired, if you remember just the 14-day period now. So those are all checks that really need to be carried out before the person starts work. We'd recommend that you consider reviewing your right to work checks from time to time, make sure they're still compliant. And it's helpful to have one person on your staff who has ultimate responsibility for those right to work checks, I think, so that if people have questions, they have somebody to go to talk to about them. So that's the end of our presentation. We have received a few questions. I think, Charlie, we have time to run through those.
Yeah, we do. Thanks, Vicky. So one for you, Vicky, which is that someone's asked, our UK office, this is from Anna, our UK office does not yet have a Tier 2 licence, but we do want one. How do we apply to get a licence?
Great. Well, Anna, thank you. That's a really great question. So if you don't have a Tier 2 licence, then there is an online form which you will complete, and you submit the online form, and then within 5 working days you have to submit a pack of documentation to the Home Office, and that's to show that you are operating a trading entity in the UK. So the documentation that you have to submit really depends on the age of your company. For new startups, to start companies which are under 6 months in age, it would include things like employer's liability insurance, evidence of a bank account, would be 2 of the things. You then would have to submit another 2 documents, one of which will be evidence of your relationship with any overseas entities if you're part of a group and you want to transfer staff members from those group entities into the UK. And then something like registration for VAT or PAYE or a lease for your UK premises. And because it may take a little bit of time to get those documents together, you would recommend that you get everything arranged before you submit your online licence. The other thing to remember is that if you want to sponsor somebody under Tier 2 General, so that's normally someone who doesn't work for you, you would need to advertise that position for 28 days in accordance with specific government rules before you can make your sponsor licence application. And the rules are quite strict about how to advertise that position. So I'd recommend that if you're in that situation, you contact Charlie or myself, and we can sort of help you through the advertising process to make sure you're compliant. I think licence decisions at the moment, I'd say maybe 3 to 4 weeks.
Yeah.
And that would depend a little bit on whether the Home Office decides to audit you in connection with that application, which is something they can choose to do. If they do visit you, it may take a little bit longer for that decision to be issued.
Okay, thank you. And one for me from Anne, who's asked, do European employees have to have private health insurance to ensure that their permanent residence is accepted? So there is no need to have insurance for anyone who's relying on employment time as their qualified person time. So the easy case is someone who's got 5 years of employment, they don't need to prove any insurance, and all they need to disclose to prove their residence and their employment is 5 years worth of P60s, or alternatively pay slips, at least 3 pay slips a year, ensuring that there aren't more than 6 months gap between any of the pay slips. And HR teams should be able to access those P60s and provide them to employees.
I think the other thing to consider it there as well is that you might have an employee who, say, worked for a couple of years, went to university or college and studied for a little bit and then came back to work. If that was the case, then they would need the private health insurance during the period that they'd studied.
Yeah.
Or, for example, if they were self-sufficient, so they weren't working and could support themselves through their own savings, again, you would need the private health insurance during that time. So it's just something to bear in mind for maybe a slightly more complicated application.
Yeah, absolutely. So any period in the 5 years that was as a student or financially self-sufficient, insurance is needed for that period. Otherwise, if it's just employment, no insurance required, which makes it easier. Another European-based question here: can a European applicant reapply for permanent residency or for a registration certificate if their original application is rejected? Well, yes is the simple answer. Anybody can reapply after a rejection. Obviously, the applicant would need to ensure that whatever reasons the application was originally rejected are sorted out, and that the issues are resolved. So it might be adding extra supporting evidence, it might be ensuring that insurance evidence is there. Whatever the reason is, obviously that would need to be sorted out, but there is no ban on reapplying, and that's what many people have done, partly because of that 28% rejection rate we mentioned earlier. So a question now, switching back to Tier 2 from Dominic. Are you aware of any further planned changes to the Tier 2 visa system, or can we expect a period of consolidation now? So that's one for Vicky.
Yeah, Dominic, thank you. It's a really interesting question. I think that we can expect maybe a more stable few months now, because the changes that have been introduced in November and April were ones that we were aware of from some time back. What we weren't aware of was when they would actually be introduced. The government has introduced some quite big changes this April, so the skills charge and the rollout of the IHS to Tier 2 intercompany transfer visas. So I think at the moment the government's focus, in my view, and I'm sure Charlie will chip in, is that government will be focusing on how to make decisions about the rights of EEA nationals to remain in the UK after Brexit, and will leave Tier 2 alone for a little bit. Historically, government changes have taken place on Tier 2 in either October or most normally in April of the year. So we wouldn't expect large changes in the next few months. Probably the changes would be saved for next April. One thing that I think may be introduced in the future, which is based on a change which came in on the 6th of April, is that the government has asked certain professions of Tier 2 applicants to provide criminal record certificates for previous time spent outside the UK, and that's in social care, sort of health, teaching. And that's a requirement for other types of non-Tier 2 visa applications. So I wonder if in the future the government might require all applicants under Tier 2 to provide these criminal record certificates. So that's something that maybe I can see coming in, which would just be an administrative step that was needed to be taken in connection with making the Tier 2 application. But Charlie, I'm not sure if you've got any thoughts on that one too.
Well, I agree with that point about the criminal records check, and what the impact of that will be to increase the hiring timeline for particularly for certain nationalities. So to take applicants in the US, for example, a US citizen can get a criminal records check very quickly using a fast-track service at the FBI, but other nationalities who are residents in the US aren't eligible to use the fast-track, and that can often take 8, 12 or more weeks to process, which will impact on the hiring period. In terms of the larger picture and on changes, I think I agree with Vicky that in the short term the government's going to be preoccupied with Brexit, but longer term, if they are going to make headway towards that 100,000 net migration target that we've both talked about, the only way they'll get there is to do something radical, and that's where there may be some further restrictions on the system. So, a question from Polly back to the European applications about private health insurance again, and this is about the job seekers. Are they in the same category as employed workers, or are they treated like students and self-sufficient? So job seekers are treated the same as employees in that they don't need to prove that they had insurance for that period of job seeking. So, and typically a period of job seeking of up to 6 months shouldn't cause a problem in the 5-year continuous period. What the applicant will need to disclose is lots of paperwork to prove that they were actively seeking employment, so registration with employment agencies, job application, rejection letters for unsuccessful applications, as much paperwork as possible, but they won't need to prove that they had insurance for the period of job seeking. Good. Well, I think that wraps up everybody's questions. Thank you so much for joining us today. We're finished within the hour, so please do stay tuned to receive alerts of our future webinars. We'd love you to join in again, and we will speak to you again soon. Thank you very much.
Thank you. Goodbye.